Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you take it from there. June 20th, Supreme Court opinion, McLaughlin Chiropractic Associates Incorporated v. McKesson Corporation. All right, this one is kind of the definition of like in the weeds or inside baseball, but I am going to attempt to give you the cliff notes. So let's go, baby. The general question being decided here is whether district courts and civil enforcement proceedings under the Telephone Consumer Protection Act, or TCPA, are bound by the interpretation of that act by the Federal Communications Commission, or the FCC. So you have the TCPA, and the FCC interprets that and tells the courts what to do, basically. And the general question is, in civil enforcement proceedings, does the district court have to be bound by that interpretation? The TCPA prohibits unsolicited fax advertisements without opt-out notices and provides a private right of action, basically an award in a suit, with minimum damages of $500 per violation. McKesson Corporation sent unsolicited fax advertisements in 2009 and 2010, leading to McLaughlin to sue in 2014 for TCPA violations. They sought damages and an injunction for a class, a group of people, of fax recipients, including those receiving faxes via traditional machines and online services. The district court certified the class, but following the FCC's interpretation of the order, which excluded online fax services from the TCPA's definition of telephone facsimile machine, actually just granted summary judgment to McKesson for claims involving online taxes, decertified that class, or the group of individuals, and awarded McLaughlin $6,000 for 12 traditional faxes. The Ninth Circuit affirmed, citing the Hobbs Act, which grants courts of appeal exclusive jurisdiction to review FCC orders. The Supreme Court, however, stepped in and reversed that decision, holding that the Hobbs Act does not bind the courts in enforcement proceedings to the FCC's statutory interpretation. The Hobbs Act's exclusive jurisdiction to determine the validity of FCC orders applies to pre-enforcement declaratory judgments, not enforcement proceedings. So basically, the Supreme Court is saying to the lower courts, you do not have to abide by the FCC's interpretation of the TCPA. You have to look at the statute and decide for yourself how it applies moving forward. The Supreme Court therefore reverses the decision and remands the case, leaving the TCPA interpretation issue for the lower courts. Kaimo, keep your mind open, do your own research, form your opinion. See you on the next one.